Creating a last will and testament that's legally binding in Minnesota doesn't have to be a daunting or expensive task. In fact, wills can often be made by oneself and without the need to seek legal advice if provided the right guidance. In this video, we will cover the importance of wills and what happens when one isn't made, what's included in wills, legal requirements in Minnesota, and how and where to create an official will. Let's begin. Wills and their importance. A last will and testament, also simply known as will, is an essential estate planning document that dictates how an individual's assets will be transferred upon their death among family, friends, and other beneficiaries. It's recommended for all adults to have a will in place, particularly those who are of advanced age or facing serious health conditions. Now, what occurs if no will is left? A person who passes away without a will loses full control of who inherits their property. Instead, Minnesota inheritance laws will determine how the deceased assets are managed. Typically, the deceased spouse, children, or close relatives inherit the property through a set formula. Disputes can commonly arise between loved ones regarding rightful heirs to certain personal and real property. It's best to set the instructions in writing by drafting a will. Fortunately, one can draft a clear will document rather simply and often without an expensive attorney required. A person of sound mind can draft a will in Minnesota with the following information on the document: their full name and residing address, the information of their personal representative, also known as the executor, who will manage the estate accordingly, the names of all beneficiaries, and a thorough list of assets each shall receive, any additional terms and conditions, the signatures of the testator, and 2 witness signatures. And finally, let's review a few legal requirements in Minnesota. Last will and testaments in Minnesota must be signed by the person to whom the will belongs, known as the testator, in the presence of at least 2 trusted and competent witnesses. Though optional, it is recommended that both witnesses be disinterested parties. Disinterested parties are individuals who do not stand to personally benefit from the will or receive a share of the testator's estate. Once created and signed, the document will be legally binding. Multiple copies can be made and given to trusted individuals for safekeeping. We're eForms, the biggest database of legal documents. We have created state-specific last will and testament templates specifically designed for Minnesota that are quick and easy to fill out. Our software generates an official document after you select your desired will instructions and name all of your beneficiaries. Click on the link below to begin creating your will. And don't forget to like and subscribe for more daily videos.